Hey, well, good day, everybody. What we should be looking at now is the exclusive listing contract. Now, one of the things I want you to catch as we are looking at this is that it is now an exclusive right to sell or lease contract. So this is for both listing, a lease listing, and a sale listing. Now, obviously, what you can see is I'm using Coldwell Banker Professionals agreement at this point, but know that whether or not you're blue or gold, these things are exactly the same like all the other paperwork that we are reviewing. So to start this out with, here's what we've got. You have the contract date. It is the date on which you're selling, what you're actually signing, I should say, the contract. From there, the listing date. The date that the listing will be submitted to the MLS, and of course, through the expiration on, this is a 6-month listing that we want within our company. 6 months is the guide. Might you take less? The answer is yes, and that is one where you need to talk to your managing broker regarding whether or not you can accept less. Most of the time it's depending upon the market, but also terms are a big key also. Address of the firm, that is the office address. Who is the designated agent or agents? Obviously, in looking at this paperwork, that's going to be you. And if there is a co-listing agent, you would put their name, both of you would be designated. Email addresses for the two of you, the agent phone number, the supervisory broker or brokers. You need to find out from your managing broker who they are wanting you to put in there. Some of you, that's going to be Chris Hendricks. Some of you, that is going to be the managing broker themselves directly. Who's the owners of the property? We want to put all owners in this line. Their home address. If you have additional, get the additional addresses. The owner's email addresses. Owner's phone numbers. So all of these are obviously quite obvious as to what we need for those blanks. Now, the agreement itself says, in consideration of the agreement of the brokerage firm, to market owner's property and to use its best efforts to find a buyer tenant. So this is how you'll see it throughout. It's just a matter of which way is it. You'll see how we're correcting that or making that statement. Owner gives brokerage firm the exclusive right to offer the property, and it's right here. I am going to check off, is this for sale or is this for lease? For the listing period stated above, we're simply going to put a check in the correct box. In consideration of exclusive sale rights, brokerage firm agrees to use reasonable efforts to sell the property, to present the property to other realtor companies through a multiple listing service, and to engage in marketing efforts to expose the property. Brokerage firm and owner hereby designate the agent listed above as owner's designated agent. Now again, if you had two of you down, both of you are in that situation. Owner shall have an agency relationship only with the brokerage firm, the designated agent, and a supervisory broker named above. We now get into the description of the property that we are contracting to handle the marketing, sale, and closing of. Property is located in, is it a village, a township, or a city? Obviously, we're going to fill in the blank, the city of, the county of. We're going to put the actual street, what it's commonly known as, 123 Easy Street, and then the legal description. Now, using Transaction Desk or SkySlope, guys, these typically done correctly will autofill for you. Now, from there, it's the inclusions. What's to be included with the sale of the property? The price includes all buildings, all fixtures, and I want you to notice this. All gas and oil mineral rights owned by the owner. It's passing. They may not even know, and I would tell you that most of the people you're likely to deal with will have no idea. But as we're listing it, they are included. It continues on with built-in appliances, otherwise attached appliances, lighting fixtures, plumbing fixtures, water softeners, unless they are rented. That's something that you need to check on when you find these. Heating fixtures, electrical fixtures, radio and television antennas. Yep, they still exist. And any mechanical controls, shades, awnings, shutters, window blinds, curtain and drapery rods, attached floor coverings, attached fireplace doors and screens, garage door opener and controls, screens, storm windows, doors. Here's one to remember, especially if you're in rural areas. Stored heating or cooking fuel. Anything left in the tank is being transferred with the property. Landscaping, fences, invisible ground, in-ground fencing and related equipment. Collars. Mailboxes, TV mounts and brackets. Notice it's TV mounts and brackets, not the TVs themselves. We are giving clarification by stating it that way. And of course, then you're going to list out all other personal property that would remain with the property. Now, it's important here that the next line is stating what is excluded from the sale. What we know is anything that is permanently affixed to the property is now real property, and therefore it is included in the sale. If something is stated by the seller that is permanently affixed, and they're saying, oh, by the way, we're taking that, it needs to go in this line. And of course, what are we going to advise the seller that they should do before we start showing the property? Get that out. Remove it. And if it's something that should be replaced, like a ceiling fan, a chandelier, something of that nature, replace it before the first showing. And then remember this, if it's not, it's included. And it must be excluded from the PA. Moving on, we're talking year built. You need to know what year it's built. Look, there are some where there are no records because they are that long or that old. We need to give an estimate and state basically in such that it is just an estimate. We're checking off for lead-based paint. Was it built prior to 1978 or after 1978? We're going to correctly check the proper appropriate box. Moving on, we're going to take a look at the next page here. Price and terms. The brokerage firm is authorized to sell the property for the sum of blank, what's the price, or lease the property for the sum of. And that's where we put the monthly rent. So it's subject to the following terms and conditions, or at such other price, and or on such other terms and conditions as the owner, landlord may agree to in writing. We're then going to check off what is appropriate. Are we taking cash? Cash to a new mortgage? Cash to an existing mortgage? Really, it would be an assumption of an existing mortgage. I do believe that these will become more and more prevalent if they are there, and the current loan or mortgage on the property, excuse me, will allow for an assumption of the loan. Land contract. If it is a land contract, then we're going to fill in what the terms, the basic terms of the contract that the seller would be willing to entertain. And if so, are we going to include taxes and insurance in the payment? Check yes or no. Let's move on. Paragraph 4, the listing broker's compensation. So if something you've heard or it's in your vocabulary, I want you to get rid of the term commission when we are talking with buyers and sellers. It is our compensation for services. Our broker pays we salespeople a commission. Buyers and sellers pay compensation. So, the listing broker's compensation, the broker's fee for services rendered, is not fixed, controlled, or recommended by law, the MLS, or any person not a party to this agreement, and it is fully negotiable. That is required, what do I want to say? Required language that must be placed on the agreement. So, thus the reason that whole statement is bold-faced so that everybody can see it and not miss it. It then goes into this. If during the term of this listing, anyone produces a buyer ready, willing, and able to purchase the property at the listed price and terms for any other price, terms, or exchange to which owner consents in writing, owner agrees to pay brokerage fee, firm 6%. Now, I'm recording this in early 2026. It is 6%. As we continue to go through with all of the activity that's going on in real estate currently, there may be different ways for us to be able to approach sellers. But at this point, we still want to have 6%, and this is to cover us as a brokerage firm for both what if not only do we list the property and get it sold, but we happen to have the buyer as a listing firm. We're covered and in many, many different ways. But today it's all about what goes in this purchase or in this listing contract. Today we're looking at 6%. Now, if, it's the blank amount for, you could have a flat amount. Here's what we charge. This would be in circumstances where maybe somebody came to you and you're charging a flat fee for it because you're doing some minimal services. On the other hand, it could be that you've got a low price property and you just want to make sure that you collect a reasonable amount because 6% wouldn't really be enough for the amount of work that you would put into it. That's where you would put in the dollar amount. And notice it just says, and a fee of $495. And if anybody says, well, what's that for? It's part of our compensation. Mr. and Mrs. Seller, that's just part of our compensation. Our compensation is 6% plus $495. Now, if it's a lease, owner agrees to pay the brokerage firm blank percent of the total rent due for blank months. Typically, that's for 12 months. I like the idea of 10%. Often you'll see that it's 1 month's rent is what is offered. Okay? 10% is a little bit better deal for that, and then offer the 3% or a half month out for a buyer's agent. Something to consider, but you'll make more money, and especially as a listing agent, which is what you should do when you're handling a lease. Further, if within 6 months, guys, this is what is called the protection clause. Further, if within 6 months, if you want to go 12 months, fine, but 6 months is a minimum. After the expiration of this agreement, owner sells, trades, leases, or exchanges the property to anyone introduced to the property during the listing term. The stated compensation will be paid by the owner to the broker, unless at the time of the sale the property is listed with another broker. It's an important distinction because some sellers will read this and not be comfortable with it. It doesn't tie them to us after the expiration if they list with another broker. For purpose of this paragraph, sales shall include a subsequent sale pursuant to an option granted during the applicable period. It is also agreed that in the event of the trade or exchange, the broker is authorized to represent and receive compensation from both parties to the transaction. So it's coming right out and saying we can represent both here and get compensation. In the event of litigation involving the compensation to be paid to the brokerage firm pursuant to this agreement, if broker is the prevailing party, owner shall reimburse brokerage firm for its reasonable attorney fees and expenses in connection with such litigation. Otherwise, if there's any issues that comes along and we are sued and we are winning in our suit, if we win our suit, they would be responsible for our attorney fees and any expenses. Moving on. We know with the settlement that occurred that there's all types of things that must be specified. This is simply an agreement with the seller where they're going to direct us as to how much of the compensation that they're providing us that they are willing to pay on behalf of a buyer. So let me read it for you. Whether the listing broker will offer a portion of the listing broker's compensation set forth in the paragraph 4, previous paragraph, brokerage firm producing the buyer tenant, otherwise do we offer anything to someone else who brings the buyer, is wholly within the owner's discretion. The seller, you decide whether or not we do this. It is not fixed, controlled, or recommended by law, the MLS, or otherwise. And then it states, the owner directs the brokerage firm to A, offer portion of listing broker's compensation producing sub-agent. That's what I want you to catch. Guys, we don't want to do this. I am going to advise a seller not to offer. The reason being is think of the worst real estate agent that you could work with. Not that there are any. What control do you have over their skills, their knowledge, what they do, what they tell a buyer? Key being is they're acting as a sub-agent. They would be working under our direction. And yet we have no control over their abilities, their knowledge, their skills, what they do, how they work. We don't want this. We don't want this for us. We don't want this for our seller. We want to sever any tie to any other agent outside of our firm. B, offer a portion of the compensation for a buyer's agent, in short, is what this said. Said offer of compensation will be blank percent. If we're getting 6, we're going to put 3 here. You could put a flat amount. We will offer also C. It's for transaction coordinator. It would be the same amount that we put for B. There is no reason to offer less to a transaction coordinator. Make sure that you watch, listen, and learn in regards to agency, because the only change between a transaction coordinator and a buyer's broker with where we're at, they owe no fiduciary duties to the buyer nor the seller. Yet they provide all of the other services to be able to get this buyer into a home. Now, D says no offer of compensation. Don't even offer any. We won't pay it. Hey, if that's what they want, that's their choice. Paragraph 6. Concessions. Now, this is money that a buyer may ask for, a seller may offer to make their property more marketable. It may make sense, it may not. Let me try that again. May not make sense. It may or it may not. It's really every situation is different, and that's what you're the expert to be able to help guide a seller toward. Now, here's what it says. These concessions would be not offer of compensation for a buyer broker's fee, but rather money that could be applied toward closing cost taxes, prepaids, or any other allowable expense that a mortgage company might allow. In addition to the compensation offered by brokerage firm pursuant to paragraph 6 above, very clearly stated it's a separate amount, if any, owner does or does not authorize the brokerage firm to advise potential buyers of their offering any compensation. It's at their sole discretion. And then it finishes with this. The invitation shall or shall not be disclosed in the MLS. Most MLSs have this opportunity. Some of them won't. But this is, if yours does, you need to find out whether or not they want this disclosed. So we'll run it from there. That's pretty much self-explanatory. Let's go to paragraph 7. Participation in a multiple listing service. This is not an option. We're just telling them. You are authorizing us to file this with any multiple number of listing services. Any multiple listing service. Any and all, as many as we want. Or any other medium selected by the brokerage firm, and provide any such multiple listing service with a copy of this agreement. Any changes to this agreement and any post-closing information, including the sale price. Otherwise, we get to disclose all of those basic things to the MLS. Obviously, that's for the benefit of everyone because of, if nothing else, appraisals. Title. Owner represents that the title to the property to be good and marketable title, and owner will execute and deliver a warranty deed, land contract, lease, or other instruments of assignment or conveyance as shall be required by this agreement. By agreement on a subsequent purchase agreement, owner will provide at owner's cost an owner's title insurance policy in the amount of purchase price. Now, what we have to remember is that there are two types, in generally speaking, two types of title insurance. One is an owner's policy. An owner's policy is provided to a buyer who purchases the property. An owner's policy is commonly provided by the seller because the seller is responsible by law to pass clear title. To show that they were passing clear title, they provide title insurance. I want to throw this out too because you'll often hear that it's a big scam. Title insurance is a big scam. Well, what we have to remember is that it's not just insurance for clear title, but rather what did the title company have to put in to be able to, offer title insurance? Well, they've reviewed the entire history of the property, the chain of title, and the abstract of title. They're the ones saying that as long as all these things happen, we will issue a title insurance policy. So that's the reason for it. It's not just the insurance, but what they had to do to be able to offer. Everybody wants to know that they've got clear title to the property they're acquiring. Now, the other that you may see is when there's a mortgage, in which case there's a mortgage policy of title insurance. Obviously, that's going to be provided by the buyer, and that's given to the mortgage company who's lent the money. All right? So keep that in mind as you go along and know that that's some of the key part to understand. Special assessments is saying the owner is agreeing to pay at or before the closing any special assessments for public improvements, which have been confirmed by public authority. Either, so look at it this, they may not even be in, but if it's been levied, they're agreeing to pay that, which have been confirmed by public authority prior to the date of closing, unless otherwise negotiated as part of the buy-sell agreement. That is a possibility. However, some municipalities won't allow it to be assumed. They will force it to be paid at closing. So, could a buyer pay it? Yeah. This agreement, we need to know, is telling the seller, you're paying it. Let's move on to number 11, default. If a sale is not consummated because of owner's refusal to perform, owner's refusal, then the total agreed upon compensation shall be due and payable upon such refusal. Seller doesn't perform, we get paid. If a sale is not consummated because of the buyer's failure to perform and a deposit made is forfeited, owner agrees that said deposit shall be applied first to reimburse the brokerage firm for all expenses incurred by brokerage firm on owner's behalf, and that 50% of the remainder of such deposit, but not in excess of the amount of the total agreed upon compensation, may be retained by brokerage firm in full payment of services rendered in this transaction. Guys, it's covering our backside, but typically we've not taken any of the money forfeited on buyer default because we're still going to sell the property. So circumstances apply, but it gives us a right to be able to collect that money. Talk with your managing broker, obviously, whenever you're having any type of trouble with a transaction. Required certifications or inspections. If a certification and or inspection of the property is required by local ordinance, state, or federal law, owner agrees to pay for said certificate of inspection. Owner further agrees to have any and all required repairs by such certification inspection made, provided they do not exceed blank dollars, unless the requirement for repairs is waived by the buyer. You've got to get into all of the different areas and know when these certifications or inspections are required by a municipality and how will they allow you to handle them. So it's a key part for you to catch, as you need to know what your area actually has and requires. Typically in a situation like this, you could put $0. The seller's agreeing at this point, they're not going to put any money toward repairs. On the other hand, maybe it's $500. Check with your managing broker, your mentor, and find out what may be typical for your area. County well and septic compliance. Owner agrees to comply with county well septic inspection ordinance, if applicable, and to pay all costs necessary to provide the county health department approval to the buyer. There are known areas where a county or a local municipality may require well and septic inspections. You need to know what those are. Make a note, check with your managing broker. All right, coming back, we are on paragraph 14, showings and signs. And here's what we say. Brokerage firm may photograph the property and publish pictures, advertise the availability of the property through any medium, place a for sale sign or for lease sign on the property, and remove any other for sale signs, and show the property at reasonable hours. Owner acknowledges that the use of certain advertising will result in the contents of the property being made known to third parties and consents to such advertising. So it's kind of the warning of seller, get rid of the things that you don't want everyone exposed to, because what they see is going to be out there online. So you don't want something being exposed? Take care of that. Release. The brokerage firm is not responsible for the security of the property. Owner releases and holds harmless brokerage firm and its agents and cooperating agents from any liability for loss or damage to the property by third parties. Such obligation to include, but not limited to, reasonable attorney fees and costs. So seller, we can't take care of everything. If there's things that you don't want out, or what do I want to say, stolen, to be frank, then you need to take care of these things, put them in a place where they're inconspicuous, locked up. And guys, that could be jewelry, drugs, obviously any firearms, things of that nature. They should just get it taken care of. Number 16 addresses lock boxes. Owner authorizes the lockbox to be placed on the property in order to permit showings of the property by other real estate licensees and to enable service providers to perform services in conjunction with a proposed sale of the property. Owners shall not disclose confidences to any other real estate licensee that owner would not disclose to a potential buyer or tenant. Owner releases and holds harmless brokerage firm and its agents and cooperating agents from any and all liability as a result of injury to persons or damage or loss to property arising out of the owner's grant of access pursuant to this paragraph. Such obligation to include, but not limited to, reasonable attorney's fees and costs. So it's giving us the authority to use the lockbox and to grant access to qualified individuals who are to receive access. Inquiries and referrals. Owners agree to refer brokerage firm all inquiries received concerning the property during the period of this agreement. This is literally saying, Mr. Agent, Ms. Agent, that the seller must turn over any inquiries that they get regarding the property. I want you to think about that for a moment. They have to give them to you now. That's why it's called an exclusive right to sell agreement. Number 18, additional offers. Once owner and buyer tenant enter into a binding sales contract or lease agreement, brokerage firm shall not present to owner any other offers or applications unless owner and brokerage firm agree to otherwise in writing. So it doesn't matter what state law is giving us. What matters is what now is in writing. So keep this one in mind because, one, there shouldn't be any other offers, but if it weren't for this, we would have to present those offers if they were to come in any way whatsoever. Number 19, possession. Possession is to be given blank days after close of the sale, subject to the rights of the present tenants if there are any. An occupancy charge, if any, will be agreed upon by owner and buyer tenants. Listen, it's pretty much okay to put 0 here, because it's going to be what the buyer and the seller agree to, but it's more of what are we going to market out on the MLS. The less possession time, immediate possession is basically more marketable than what it would be if we had 30 or, geez, forbid 60, but it's more marketable the less time we have. Citizenship. And guys, you gotta ask. You gotta get confirmation. Are you a United States citizen? Checking yes or no. This is not anything that has to do with politics, race, religion, any of that stuff. It's just, are you a United States citizen? We need to know this for at the time of closing. If they have a sale over $300,000, then FIRPTA jumps in and look at, I'll tell you what, if we discover at closing that they were not a United States citizen, they could have, I believe, 25% of their proceeds retained. Maybe it's 50%. Bottom line, you need to know this one, okay? Let's go to page 4, errors. Simply stating, this agreement shall be binding on the heirs, personal representatives, administrators, executors, assigns, and successors of the owner. Pretty much, I'm going to call it standard legal jargon. Needs to be there. Non-discrimination. I'm going to read it because it should be self-explanatory, but here we go. It is agreed to by the brokerage firm and owner parties to this agreement that as required by law, discrimination because of religion, race, color, national origin, age, sex, disability, familial status, or marital status by said parties in respect to the sale or lease of the property is prohibited. Local ordinances, and this is important, local ordinances may offer protection against additional discrimination. We need to know what those are in the areas that we practice. But again, you know what? Everybody's the same. They're all green because that's the color of the money. I want to get into the showing of property, paragraph 23. It states it is a conflict of interest, but this is addressing our opportunity to be able to practice with dual agency. So here we go. Owner understands and agrees that as part of the marketing of the property, designated agent will show potential buyers, tenants, properties other than the owner's property, and provide such buyers and tenants with information on the selling prices in the area. Otherwise, I have other homes that I must show. I represent buyers. I have to protect their best interests also. We're receiving the permission to be able to show them other properties other than just this listing. Owner also agrees and understands that designated agent can show the owner's properties to, and obtain offers from, all prospective buyers or tenants, including buyers and tenants with whom the brokerage firm has an agency relationship. But we continue further. If a potential buyer tenant is represented by a designated agent within the brokerage firm other than the designated agent, this is a disclosure of the supervisory broker. The brokerage firm and supervisory broker shall automatically be deemed disclosed consensual dual agents. We're going to reiterate this if it comes up on our purchase agreement. But now we take it a little bit further. If a particular buyer tenant is represented by the designated agent shall notify both owner and the buyer/tenant. And designated agent shall act as a consensual disclosed dual agent of both owner and buyer/tenant. This paragraph gives the brokerage, the supervisory broker, and the designated agent the authorization to practice dual agency. We must do it correctly by disclosing the change in our agency relationship. That's all this is it. So, yes, we can do our brokerage, our supervisory brokers, and you as an individual agent have permission to practice dual agency. We've just got to do it properly and legally. Next paragraph under paragraph 23 states this: in all cases, brokerage firms shall be entitled to the total compensation provided herein. That was part of the address of why we want to do 6%, even though we're only going to be charging the seller 3%. Designated agent will preserve any confidential information obtained during another agency relationship or in a prior or pending transaction or business relationship. You may have had something, and it's stating that we are going to hold that private, because confidentiality in agency never goes away. Owner acknowledges and agrees that the preservation of this confidential information shall not constitute a breach of any fiduciary duty owed by designated agent to the owner. I think that one pretty self-explanatory. Indemnification. It's always great when you can get these. It's on here. Owner shall indemnify and hold harmless brokerage firm and the brokerage firm's agents, cooperating brokers and agents, from any and all liability for any reason as a result of injury to persons or injury to persons or damage or loss of property arising out of showing of the owner's home pursuant to the listing. Doesn't mean that we won't get sued, but listen, always we're practicing risk reduction, as we all know that one, or we should know that one. Paragraph 25, the unoccupied vacant properties. This is an interesting one that just, again, it's a point of covering that seller, you still got to take care of your home. Broker assumes no responsibility for monitoring or maintaining the property. Seller, it's up to you. Owner, homeowner, it's up to you. Or any damage that might result from weather conditions, including a freeze. Furnaces stop working. Properties can freeze up very quickly, depending upon the temperatures in our area. Broker recommends the property be professionally winterized. So we're telling them up front, this is vacant, you're not living in it. We're going to suggest, Mr. and Mrs. Seller, that you winterize the property, that the water is off, that we've blown out all the pipes, that we've got everything set, that the heat is on, electricity is to remain on. That is our recommendation. Representations. Owner hereby acknowledges that broker firm is relying upon the representation, whether oral or verbal, made by owner with respect to the property. Owner warrants to brokerage firm that any representations owner has made or shall hereafter make are true, and designated agent is authorized to make such representations to prospective buyers and tenants. We've asked them a whole lot of questions. They provided us with a lot of information that we are going to represent as being true and factual. This is just, Mr. and Mrs. Seller, you need to know, whatever you gave us, it's what we're going to represent. Home surveillance. Owner understands that use of audio surveillance device during showings, open houses, or inspection of the property may result in a violation of state and or federal criminal wiretapping statutes. So listen, don't become an attorney, don't become a legal expert, but guide them. If you've got Ring doorbells or security cameras on the inside of your house and you're recording all of the activity, they may be in violation of state or federal criminal wiretapping statutes. Unplatted lands. Typically, this is for larger parcels, acreage. And we all know that there's a Land Division Act, and then there was 1997, they came around and they created a little bit further. This one deals with the available divisions, become the clear part. And what this is saying is, are you reserving any, or are you going to give all? So if you sell all of it, just transfer all of it. You don't have any rights left over anyway. But a person may have decided to divide a parcel or parcels off of the master parcel and will reserve all of the division rights that may be existing for that parent parcel, is the term. That's what we're dealing with on paragraph 28. Owner represents that this division has been approved by the local municipality, or that approval is still necessary. We're simply checking off the appropriate box. Letters of introduction, or also commonly known as love letters, is paragraph 29. In the event that a buyer submits an offer to purchase along with an introductory letter, love letter, describing the buyer and the buyer's reasons for submitting an offer on the property, realtor will or will not forward such letter to the owner. Owner acknowledges that the consideration of information contained in such a letter in evaluating the offer to purchase may violate federal or state fair housing laws. We don't know what people are going to put in there that could be misconstrued against one of the protected classes that could then be turned around and said that, well, you've discriminated against us because. Or someone else. As a company, look, I certainly don't mind providing them. I don't know that I like providing them to my sellers. So our guidance basically is to say, seller, you don't want to receive these. Comes the bottom line. Paragraph 30, professional advice. Owner acknowledges and understands the brokerage firm, its agents, employees, and representatives are not acting as appraisers, builders, accountants, engineers, environmentalists, inspectors, surveyors, tax advisors, or attorneys in the context of this agreement or any future purchase or lease agreement. Owner has been specifically advised to seek professional input or advice in those areas from those professionals and may be advisable and prudent. It's really, let's protect our backside. Guys, we all know what we're supposed to be experts in and what we're not. Refer them off to the experts. FIRPTA. At closing, owner shall provide an affidavit of non-foreign status and otherwise comply with the withholding provisions imposed by the Foreign Investment in Real Estate Protection Act. So if you're ever wondering what FIRPTA stands for, there it is, paragraph 31. And obviously, by the way, that's going back to, are you a United States citizen? This addresses it. Seller disclosure. Owner agrees to provide the buyer a seller's disclosure statement prior to accepting a buy-sell agreement from a buyer unless the transaction is exempt under Michigan law. Owner agrees to release and hold harmless the brokerage firm and its agents and subagents from any liability arising as a result of owner's failure to comply with owner's disclosure obligations at law, such obligations to include but not limited to reasonable attorney fees and costs. So, seller, you're agreeing to do this, and obviously, if not, then we need to know why you are exempt. By the way, guys, remember this. Because they've never lived in it does not make them exempt. There is an exemption from seller's disclosure form that you should pull out and ask them to initial whichever exemption they may have. And they say, well, none of these apply to me. Oh, well, then you must disclose. Keep it simple for them and use that form. Paragraph 33, limitation. Owner and brokerage firm agree that any and all claims or lawsuits between the parties relating to this agreement must be filed no more than 6 months after the date of termination of this agreement. The parties waive any statute of limitations to the contrary. This 6 months holds true between all of our agreements. Electronic communications. The parties agree that this agreement, any amendment or modification of this agreement and or any written notice of communication in connection with this agreement may be delivered by electronic mail via the contact information set forth above. Any such communication shall be deemed delivered, and this is important to create binding agreements. Upon that delivery, we can have a binding agreement. So, again, any such communication shall be deemed delivered at the time it is sent or transmitted. Thus, you would then have a binding agreement. Offer sent, offer accepted, offer sent via email with acceptance, binding agreement. Merger. This agreement constitutes the entire agreement between the parties, and any prior agreements, whether oral or written, have been merged and are integrated into this agreement. 36. The undersigned owner represents that all parties in title are signatory on this agreement. There's not anybody we're missing, that whoever we have are and only, all and only, those who are on title. This agreement may be signed in any number of counterparts. Look, if I took this on paper and I had 5 copies so that I could give all parties to this agreement a copy, that's a counterpart. Additional conditions, therefore, you to agree upon anything that's not part of the agreement that is acceptable to you in the brokerage. When uncertain, don't do it. Cancellation. Guys, this is important. So very important. You need to know that it is able to be canceled. And you can see that when we did this, we did it underlined. Only by mutual consent in writing. A seller cannot just arbitrarily decide to fire you, nor can you arbitrarily decide to fire them. It took two parties to enter this agreement. It takes two parties to leave it. Paragraph 39, receipt. The owners received this agreement. They read it, received it. You're going to get them a copy of it. Make sure you do this because they are acknowledging. You're going to sign it as the designated agent. The sellers, all sellers will sign as owners. And of course, we're going to date our signatures. So guys, that's the exclusive right to sell, lease, contract. See you on another video.